Hanji students, how are you? Sat Sri Akal. Let's do the topic of amendment of the criminal laws in India. So, the Modi government, the present government, is in the process of amending all the three major criminal laws in India: CRPC, IPC, and even the Evidence Act 1872. Why the government is in this process? Because there are many lacunas in the criminal law in India. There are many lacunas in the criminal procedure, so many sections have become redundant also. There are certain sections which are needed to be added to the already bulky codes, I must say. So lot of changes has to be done. So the criminal law in India has to be changed, and many more sections are to be added in the criminal law. Basically, here in this video, I will tell you about the main purpose of amending the criminal laws. So basically, it's a very complex and lengthy exercise. Even this Union Minister of State for Home has said in Rajya Sabha that amending the criminal laws is a very continuous process. It's a very lengthy and complex process, and in the near future, we will definitely do this. And basically, uh, by these amendments or through these amendments, main thing is that primacy shall be given to the constitutional provisions and even the human rights, basically human rights of the accused, of the victims, and all these things. And CRPC may be made more simple. It will be made simple, unambiguous. The provisions will be made very simple, unambiguous, and there will be a consistent procedure in CRPC. So we hope so they will do that. And as far as investigation by the police also, it will be time bound now. And even the trial will be time bound on certain for certain offenses. There will be time bound trial. So this is the need of the hour. The law had to be changed, and the present government is on the way of changing all these three criminal laws. Basically, more transparency will be there, more accountability will be there. There will be balancing of rights of the victim vis-a-vis the accused. Earlier also in 2020, May 2020, there was a national level committee which suggested certain reforms in the criminal laws in India: IPC, CRPC, and Evidence Act. And the main things which should be looked into, which the committee suggested, was that there's a lot of pending cases in India. This should be looked into. There are inconsistencies and inefficiencies in the procedure relating to arrest by the police, bail, investigation by the police, trial of the case. There is arbitrariness in the police. There is high-handedness in the police actions and even the prosecutorial actions. So there should be special provisions for victims also. So main focus was to ensure safety and security of the individual, and that individual may be accused also, maybe the victim also. And basically, what you must be thinking, what would be the sections? You see, this is not clear. What sections will be added? What sections would be deleted? But there is a rumor that there can be a section of hate speech also under the topic of, there can be a new heading of in IPC, offenses relating to speech and expression, and under that there can be a section of hate speech. Now, what is hate speech? It is very difficult to define what is hate speech. As far as the IPC's sections are to be involved, then such hate speech has to lead to violence or disturbance of law and order. Besides this, there will be more comprehensive changes in IPC. You see, IPC was actually enacted by Macaulay, Lord Macaulay, during British era. So very good piece of legislation by uh, very good writer, Lord Macaulay. But Lord Macaulay was basically the chief architect of criminal laws in India. But now there is a need of reforms in these laws because they are not suiting the present circumstances in India. These laws have basically become ineffective because the purpose of the criminal justice system was to protect the rights of the innocents and to punish the guilty. But nowadays, practically we see through media and all these things that due to inherent lacunas of the system, criminal system, the system has become a tool of harassment of the common people. Instead of doing some better, instead of betterment of their life, this has become harassment of the people. You see, there are huge dependency of cases in Indian courts. You see, according to Economic Survey 2018-2019, there are about 3.5 crore cases pending in the judicial system in India, especially district and session courts. 3.5 crore. cases are pending. It's a huge bulky amount of cases. So obviously there's a maxim: justice delayed is justice denied. So there's justice denied. Here's example of justice being denied in India. Huge pendency of cases, lot of cases, 3.5 crore, huge. Then there are huge number of under trials also in India. Under trials are those persons, those prisoners whose cases are still pending in the court. Their cases are not being decided. They are still under trial. And according to this NCRB prison statistics 2015, 67.2% of our total prison population comprises under trial prisoners. They have not been convicted by the court or either being acquitted also. Their cases are still pending. Their case is still pending in the court, and they are in the prison. 67.2%, huge. Then there's need of police reforms also. You see, there's allegation of corruption in the police department. There's huge workload also on the police, and accountability, question of accountability. So investigation machinery of the police has to be cleared. It should be speed should be given to this engine of investigation. Investigation should be speedy, and there should be accountability of the police department, and a lot of things has to be done for the speedy and transparent investigation, for proper delivery by the courts also during the trial, because the outcome of the trial depends upon the proper investigation by the police. If the police does not do proper investigation of the case, then there cannot be a good judgment on the case. Trial depends on the investigation by the police. So investigation area had to be cleared, and lot of things has to be done. Lot of changes will be done in IPC and CRPC as far as investigation by the police is concerned. And earlier also in 2003, you must have been remembering, you must know that there was a Malimath committee. So what Malimath committee did, Malimath committee submitted its report to the central government. Its report was on the criminal justice system of India. So it recommended 158 recommendations. Though none of its recommendations were accepted by the government, even then those recommendations can be taken into consideration by the present present government. Some of the important recommendations were that confessions before the SP level rank police officer, it should be admitted as evidence in the court of law, because section 25 of the Evidence Act says that confession before a police officer is no confession, but it should be changed now. I hope section 25 will be changed, because this Malimath committee also recommended that the confession before SP should be admitted as an evidence. Then standard of proof beyond reasonable doubt followed in criminal cases, it should be done away with. Then presuming the accused to be innocent until proved guilty, this has to also be done away with. Instead, if the fact is considered to be proved in the court, so court can take it to be proved. And victims, especially victims, so suggestions were given to provide justice to the victims. For example, in serious crimes, victims shall be allowed to take part in the proceedings, and if the victim is dead, his or her legal representative should have the right to appear before the court and fight the case, take part in the investigation. And in case victim cannot afford services of a good lawyer because of the monetary considerations, then he or she should be provided by the state a good lawyer, and all the cost involved should be borne by the state, not by the victim. And the victim should be given the compensation in serious cases like rape cases. So the victim should be given compensation, and that's the duty of the state. That's the duty of the state, irrespective of the fact whether the accused is apprehended or not. Irrespective of the fact whether the accused is convicted or acquitted, the victim has to be given compensation by the state. Then there was a recommendation of dying declaration, that even audio video recorded statements should be, or confessions should be recorded as dying declarations, because it should be admitted as an evidence in the court. Because these days audio video evidence is readily available. You also know, say anybody saying something and you shoot a video on the mobile phone, so that is a very authentic piece of evidence, and to a large extent more authentic than the other evidence. So audio video dying declarations, audio video thing, these things has to be taken as an evidence. And as far as judges and courts are concerned, this committee, Malimat committee, suggested increasing the number of judges. Obviously, this is again and again coming. So judges should be increased, the courts should be increased, separating even in Supreme Court also. There should be different courts for criminal proceedings, and there should be different courts for the civil proceedings. So civil criminal proceedings in the Supreme Court and even the High Court should be separated from the civil work, and criminal cases should be allotted only to those judges who have a proven experience and expertise in criminal laws. So criminal cases should be, as far as High Courts and Supreme Court is concerned, the criminal cases should be given to only those judges who have expertise in dealing with such cases, because it will be very difficult for a judge who usually deals with civil cases to decide a matter on criminal case. So different courts of civil cases and criminal cases. Then there's a provision of victim protection. Usually nobody, witness protection. Usually nobody comes as a witness to the court. Everybody is afraid of this court process. Nobody comes before the court to give his or her testimony. So there should be a witness protection scheme, and witness should be provided with allowance monetarily on the same day when he is appearing in the court, and he should be given a proper seating and resting facilities in the court. Then there should be less court vacations, because there's huge number of cases pending in the courts. So this Malimat committee suggested reducing the vacation period of courts by 21 days. Then arrears eradication scheme. A lot of cases are pending. I have already told you 3.5 crore cases pending in the various courts in India. So as far as criminal cases are concerned, those cases who are at least 2 years old, they should be sent to Lok Adalat, and these cases should be heard daily, and no adjournment should be allowed. As far as one more important thing, that if the accused is a pregnant lady, or a lady with a child of less than 7 years, and there's a need to arrest her, then instead of arresting her physically, she should be house arrested. Instead of bringing her physically to the prison or to the police station. She should be house arrested. Then there's a need of replacing death sentence with life imprisonment with no chance of commutation or remission. Then there should be a reclassification of offenses. Instead of cognizable and non-cognizable offenses given in IPC, the offenses should be classified as economic code, social welfare code, criminal code, correctional code, and other offenses code. So these should be the classifications. Then there should be periodic review of the criminal laws by the committee, to be constituted by the president time and time. So these were the certain reforms suggested by Malimat committee, but unfortunately they were not accepted by the government of India at that point of time, due to lot of criticisms and lot of this criticism by various stakeholders, various organizations. But now the present Modi government has again initiated the same process to reform and change the criminal laws in India. But this process is very long, it is very time consuming, very complex process. Government is open to all the suggestions, all the considerations given by all the stakeholders, and most importantly the suggestions given by you people, the suggestions given by the common people of India. Government is open to all the suggestions by the common people of India. You see, common people of India are still having lot of faith in the criminal justice system of India. So these amendments would definitely restore the faith of common people in the criminal justice system of India. So I hope you like the lecture. Do comment on the video below so that I can learn from your comments, so that I can upload more and more videos on the similar topics. Thank you very much.